And thank you for joining me today for this Education Matters webinar, where I am going to be having a look at the Employment Rights Bill and talking a little bit about the impact we think it will have on schools and academies. Now, before I go any further, those who have been to these sessions before, can I just ask that you raise your virtual hand? I think you've got the option just to make sure you can hear me all right. Oh, good, marvellous. Nothing worse than talking to yourself. No, that's lovely. Thank you very much. For those that don't know me, my name is Abigail Brightwell. I'm a partner of the employment team here at Bracious, and I also sit on the firm's education group. Now, today's session is going to be having, as I say, a look at the Employment Rights Bill and some of the key aspects which we think or we consider will have an impact upon schools, academies and other organisations within the sector. Now, there isn't time within the time we've got today to go through absolutely everything in the bill, so I've focused on some of the key aspects which are likely to have, we think, the biggest impact. Now, I presented a webinar on the same topic a year ago after the proposals were first initially announced, and it was quite interesting to see that in some respects the picture is a lot clearer and we know where things are heading, but in others we don't appear to be a great deal further forward in terms of what we know and what we're still waiting to hear. So it'll be interesting to go through that. Now, in terms of a timeline, the Employment Rights Bill was published or introduced to Parliament, published on the 10th of October last year, and the publication was the first phase of Labour's plan to make work pay. Now, since then, it's been progressing through Parliament on its journey to becoming law, and there's been a lot of scrutiny applied to the bill in both the House of Commons, which is government dominated, and also the unelected House of Lords. Now, you may have heard references to what's been termed parliamentary ping pong to describe the back and forth between the two houses. One of the houses will suggest wording for the bill, it will go to the other, it gets sent back with amendments and so forth until such time as the final wording is agreed. Now, we are reaching the final stages of the bill, and many reforms are expected to start being introduced in April next year, although there are some key aspects which are still being debated, as you'll see as we go through today's session. Now, it's probably worth noting that relatively few aspects or provisions of the bill will come into force once it's passed. Most of the changes will require commencement regulations in the first instance to bring them into force, and then others will require some substantive further regulations and consultations beforehand before they can be brought into effect. So some things are still a little way off. What we are expecting is that before the end of this year, the bill will receive royal assent, and we are informed that on royal assent we will see immediately the repeal of Strike's Minimum Service Level Act. Within 2 months of royal assent, we are likely to see the majority of the trade union reforms coming into force, and then we're likely to see further changes in April 26, October 26, and also stretching into 2027. So in April 2026, we are expecting to see certain provisions such as the increase to the protective award for redundancies or collective redundancies, some of the family leave rights coming into force, as well as statutory sick pay reforms and the relaxation of thresholds for statutory trade union recognition. October is likely to see the commencement of the fire and rehire provisions, protections in relation to harassment, as well as, again, some more of the trade union provisions coming in. And then 2027 is when we're likely to see the introduction of equality action plans, some of the flexible working and other family enhanced family protection rights, and the 0 hours changes. It's probably worth, I should have said at the outset, that you will receive a copy of the slides and a link to the recording following the webinar, so don't worry about having to capture everything down. I've also put a link on the slide to a really useful page on the ACAS website that just has a little bit of a tracker as to when you can expect to see things coming in. So that's worth a look if you haven't already seen that. So I'm going to start off today by having a look at some of the major reforms. And the first is going to consider unfair dismissal. So the big news that's hit the headlines in the last couple of weeks has been what's been described as the big U-turn on the Labour's pledge to make unfair dismissal a day one right. And as I'm sure you are all aware, that this was a major sort of flagship manifesto pledge from the Labour Party to allow employees to be able to claim unfair dismissal from the first day of their employment. And we were going to see introduced this concept of an initial period of employment during which employers were going to be able to follow a less onerous and a light touch process. Now, there was a lot of talk about what that process would look like, a lack of clarity against how it would work with existing unfair dismissal laws. And there's been quite fierce opposition between the two houses as to whether or not day one unfair dismissal rights should go ahead. Now, what we do know now is that the day one right isn't going to go ahead, and instead we will see the qualifying period of service for employees presenting an unfair dismissal claim reduce from the current 2 years to a period of 6 months. So as a reminder, under existing UK law, generally speaking, employees must have worked for their employer for a minimum period of 2 years before they qualify for the right to present a claim for unfair dismissal at a tribunal. There are some exceptions in the case of automatically unfair dismissals. That's been the general position, and that's set out in Section 108 of the Employment Rights Act 1996. Now, in broad terms, the bill will reduce that 2-year qualifying period down to 6 months, and employees will therefore have the right to claim unfair dismissal after 6 months of employment. And the government plans to also remove from the bill the power to vary the qualifying period through regulations, which means it will be harder for any subsequent government to change that qualifying period without going another Act of Parliament being published. Now, we don't yet know exactly when this will come into force, but it has been reported that this is likely to be taking effect from the 1st of January 2027. Now, this is a significant change from the current position, and it will mean that many more employees will have the ability to claim unfair dismissal than currently do now, and 6 months isn't a huge amount of time for an employer to assess someone's performance and suitability for a role. Linked to the qualifying period changes, and what's been a much more unexpected announcement that we saw announced last week, is that we are expecting, again, it's not currently confirmed, but we are expecting to see that the cap on compensation limits for unfair dismissal claims will be removed. So again, as a reminder, currently compensation for unfair dismissal claims is subject to a cap on compensation at the lower of either a statutory amount, which currently is £118,223, or 52 weeks pay, whichever is the lower. And the government is planning to repeal the section of the Employment Rights Act which sets out that cap on compensation to remove both caps, so there'd be no limit on the amount of compensation that can be awarded for unfair dismissal claims, which is the case in claims for whistleblowing and discrimination claims. Now, I understand that this is something that is being debated in the House of Lords today again, so keep an eye out for any further updates, because who knows, the position might have changed on this before the day is out. But the impact, if it does go ahead, could be fairly significant, because unfair dismissal claims are likely to become more costly, particularly in sectors such as education and local government, where losses can extend significantly when you're taking into account pension schemes, entitlements, and also in cases of potential career-long losses. It's probably worth remembering that employees will still need to provide evidence that their losses are linked to or attributable to their employers' actions, and employees will still have a duty to mitigate their losses. But in cases of perhaps higher earners or where there is significant pension losses, this could result potentially in a lot more higher awards being made. And it may also push settlement figures up higher. And if those potential settlements expand into thresholds where Treasury approval is required, then this could then have a knock-on effect and cause more delays to any settlement negotiations that might be carried out. We potentially then may see a rise in unfair dismissal claims if this amendment does proceed. Potentially as well, we might see a reduction in claims being brought under whistleblowing and discrimination heads, because if they sometimes claims can be pursued under those routes because the compensation is uncapped, perhaps we might see more claims falling within the unfair dismissal remit as a result. While we're on the topic of employment tribunal claims, I thought it was worth mentioning that another factor which could potentially see a rise in the number of claims being presented to tribunals is that the bill proposes that the time limit for submitting a tribunal claim will increase from the current 3 to a period of 6 months from the date of dismissal. And it's anticipated that this will come into force in October next year. Again, might we see an increase in claims being presented if employees have a longer period of time in order to get their claim together and get that submitted to the tribunal? Or might actually it reduce the number of claims after 6 months or within a 6-month period? There's potentially more possibility that the employee might have moved on, found another job. Will they still want to pursue a claim against their former employer in those circumstances? But certainly it is worth keeping an eye on how this one progresses as well. So in terms of these unfair dismissal protection changes, how can we prepare? Well, I think it's probably a very good idea to start reviewing your current probation period review processes, because it's going to be really important that all new starters have a probationary period and that there is a really robust process in place to ensure that their performance is reviewed regularly within that period. And having a structured review process will be key, as will having systems in place to ensure that any concerns are addressed at an early stage and not left unaddressed. And training managers in a consistent way, so reviewing your disciplinary and dismissal policies and making sure that managers are trained on managing those policies and conduct and performance issues within the policies is going to be really important to make sure that probation periods are used in the most effective manner. And it's also worth having a look at your recruitment processes, making sure that, again, they're really robust so that the right people are being recruited for the roles. Moving on now to look at another area which will have a significant impact upon schools is the reinstatement of the school support staff negotiating body. Now, currently there's no national pay body for school support staff, and most support staff are employed on terms and conditions set by the National Joint Council for Local Government Services, or for academies perhaps set locally. Obviously academies and have some more autonomy to set their own pay and conditions. Now, the intention is that the school support staff negotiating body will be reinstated. This was abolished back in 2010. And this will replace the National Joint Council in pay and conditions negotiations for roles including teaching assistants, administrative staff, catering staff, and caretakers, amongst others. Now, the remit of the body will also include not just pay and conditions, but training and career progression opportunities for these staff. Now, the DfE said that the government would consult on the detail of the legislation, and the consultation has taken place earlier this year in the summer. And it covered how school support staff would be defined, confirm which staff are within the body's remit. It asked well, it called for evidence on pay and terms and conditions on which school support staff are currently employed, and it also asked for views on whether agency workers should be included within the scope in future legislation. Now, a response to the consultation was due in autumn 2025. It hasn't yet been published, so we are waiting for the response in order to view further details. Once the consultation has been published, there will be a need for secondary legislation, so we don't yet know exactly what the impact will be, but it could be a significant change, and it certainly will be a change from where we are now. In terms of a time frame, the government's sort of fact sheet suggests that any decisions, sorry, skipped too far ahead, any pay-related recommendations by the body, it's estimated won't be before 2027 to 2028 at the earliest. So again, we are a little way off from these from the body making such recommendations at the current time. In terms of the role or the proposed role of the body, I won't go through it all now, the details will be on the slide, but essentially it will have a statutory remit to negotiate and recommend a core national framework and grading structure for school support staff, as well as setting minimum terms and conditions for those staff. Now, some academies have raised some concerns about how it might impact their flexibility to have the freedom to set pay at levels they determine, and it could lead possibly to potentially higher wage bills and higher wage costs. Now is, we would say, a good time to carry out an audit of your pay and contracts and identify where they might differ to the National Joint Council framework. Certainly keep an eye on updates in terms of announcements on and the publication of the response to the consultation, as well as reviewing what potential impact this could have on your budgets. Now, I mentioned earlier that a number of trade union reforms are likely to come into effect on royal assent or fairly shortly after. And this is an area where there is a lot of change coming and relatively quickly. And we are going to see a significant expansion of trade union rights in a number of areas. So I mentioned earlier the repeal of the Minimum Service Level Strikes Act, which allowed the government to enforce minimum levels of staffing during strikes in sectors including education. That will cease to apply and will take effect likely this year once the bill receives royal assent. In reality, I think the Act had a fairly limited impact in practice as it wasn't particularly utilised, so we're unlikely to see huge changes as a result. Of bigger significance is that trade unions will gain a statutory right to access schools. So the unions will be able to request an access to the workplace agreement from employers to provide access to meet with their members, recruit new members, support members with an employment-related matter, or to facilitate collective bargaining. It won't be to come onto school premises in order to organise industrial action. That will not be within the remit of an access agreement. If there is any dispute over the access agreement, then those cases will be referred to the Central Arbitration Committee. And access could include both physical entry and digital communication, such as email, etc. Now, this is an area where certainly safeguarding considerations is going to be critical for schools. You're not going to want union members turning up unannounced and demanding access to the school. So safeguarding is going to be something I'm sure that will be of pivotal importance to schools when negotiating with unions on the content of the access agreements. Again, this is subject to consultation. It's due to shortly close, and we're likely to see this coming into force much before April 2026. But again, it could be of significance, and it's worth keeping an eye on that time frame. We're seeing some major repeals to the Trade Union Act 2016, including making it simpler to carry out industrial action ballots, So currently there's a requirement that at least 50% of the trade union members who are entitled to a vote in a ballot on industrial action must do so in order for the ballot to be valid, and that's actually 40% threshold in defined important public services such as education. That will be removed and replaced with a requirement of a simple majority of votes cast in favour of strike action. This is likely to be introduced 2 months following royal assent. The rules on industrial action are going to be simplified, so including the strike ballot and notice requirements, they're going to be relaxed. Electronic balloting will be introduced, and a simplified trade union recognition process. So essentially it will make it easier for trade unions to gain statutory recognition. Expected in 2026 is that employers will be required to provide their employees with a written statement confirming their right to join a union. Further details are going to be set out in the regulations. It's likely the statement will need to be given at the same time as you give employees your Section 1 statement of particulars of employment. Again, there's a current consultation underway which shortly closes in respect of this. And then some further strengthened protections for trade union members, as well as additional entitlements to provide facilities and paid time off for union officials. So I think the upshot certainly here is that many schools, academies and those within the sector have already seen increased levels of trade union activity over the past few years, and more requests for trade union recognition. And it's very likely that as a result of these changes, we are going to see a much stronger presence of the trade unions. So in cases where you might be considering staffing restructures due to potential financial pressures, then it's likely that more trade unions will be commanding a presence in those discussions and potentially seeing a rise in the number of industrial actions taking place. I think overall the picture is that the government's plans are likely to mean that trade unions have a much greater role to play in employee relations. As a very minimum, it's going to be easier for trade unions to call strikes and harder for employers to manage those. And it will also mean it's easier for trade unions to seek recognition. So as we've said, keep an eye out for the consultations and the regulations for further details. And as always, managing disputes to prevent escalation at an early stage is always going to be key. I've set out on the slide some changes to flexible working, which we are expected to see implemented perhaps in 2027. Currently, employees do have the right to request flexible working from the first day of their employment. That was introduced in April 2024, and employers can refuse a request based on one of 8 business reasons set out in legislation. There is a penalty for breaching the statutory flexible working regime of 8 weeks pay, which based on current financial caps is capped at £5,752. Now what the bill proposes is that employers will only be able to refuse a flexible working request if it's reasonable for them to do so. They must consult with employees before refusing a flexible working request, albeit accepted in practice that most employers do this anyway. And they must also state the ground for refusal and explain why it's reasonable to refuse the request on those grounds. So the changes don't seem particularly groundbreakingly different from what's already in place at the moment, but the sector has been typically an area where flexible working can be harder to implement. Under these proposals, it's likely that it will become more difficult for an employer to refuse requests. We do seem to be moving slightly towards a test which mirrors the reasonableness test that you see in unfair dismissal claims. So it does remain to be seen how an employment tribunal would apply scrutiny to an employer's decision to refuse a flexible working request. Will it make the decision on what it would have done, or will it consider it against a band of reasonable responses? These are all things that we will need to wait and see as things develop. And although we're unlikely to see any implementation in this regime until 2027, it would be useful to review your flexible working policies, check that they would reflect a day one right if they don't already, and start to prepare for a shift, if you can, towards flexible working, and identifying those roles where flexible arrangements may be operationally challenging and documenting the rationale as to why that is. And as with probationary periods, it's a case of training managers to be able to assess requests fairly and consistently, and to be able to clearly explain why and on what grounds requests are refused if that's the decision that's reached. Now, an area which has gone slightly under the radar in terms of attracting sort of headline news is in respect of public sector outsourcing, but this is something that we do think, well, we do see that will have an impact on the education sector. And this is the provisions within the bill designed to protect workers who are working for the public sector under outsourcing arrangements, to ensure that those workers are not treated less favourably than any staff who transfer in from the private sector, and essentially make sure that there's no two-tier workforce in outsourced public services. Now, it's expected that this will be implemented, or certainly the two-tier code will be is expected in October next year. And essentially what the bill would do would change public procurement laws, which could have significant implications for private sector employers when public sectors are outsourced. Further details are awaited, but the changes could have potentially significantly affect procurement in schools, particularly in relation to things like cleaning contracts or catering contracts, because less private sector employers may be willing to take on the services due to the increased costs of delivering those services if they need to maintain parity with the enhanced public sector terms. And the regulations may also set out some provisions to be included in an outsourcing contract to ensure that neither the ex-public sector worker nor the private sector worker are treated less favourably than the other group. Again, we're still waiting for further detail as to what is meant by less favourably, but we think this is an area really to keep a very close eye on, because the impact, as we say, could be quite significant. The bill also contains some enhanced protections in relation to harassment, and essentially we're going to see a stronger duty to prevent sexual harassment. Now, there were some changes introduced last year in which the Worker Protection Amendment Act was introduced, a new duty for employers to take reasonable steps to prevent sexual harassment of employees in the course of their employment. And as originally drafted, the legislation contained the wording "all reasonable steps." However, that duty was slightly watered down before the legislation passed to provide that employers must take reasonable steps to prevent sexual harassment in the workplace. Now, what the Employment Rights Bill will do is to place that stronger duty on employers, and it will widen the test to all reasonable steps. Now, there is power within the bill for regulations to be passed which will set out what exactly is meant by reasonable steps, and it could include things like making sure a risk assessment is carried out, implementing harassment policies, and rigorous complaints procedures. And this one's expected to come into force October next year. Alongside that, employers are going to have increased liability for any harassment that takes place against one of its employees from a third party in the course of employment. And there will be that, again, onerous duty to take all reasonable steps to prevent such harassment. It's not limited to sexual harassment. It would cover all types of harassment. And again, we're expected to see that one come into force in October 2026. In addition, the bill will amend the whistleblowing provisions in the Employment Rights Act to explicitly include sexual harassment as a relevant failure, in relation to disclosures qualifying for protection under the whistleblowing legislation. And essentially a complaint of sexual harassment at work will be treated as a protected disclosure under the whistleblowing legislation. Query whether that might already be covered in any event, but it will now certainly be explicitly set out within legislation. Now, many schools, academies, and employers already have put in place reasonable steps to prevent sexual harassment in order to comply with the duty that was introduced in October 2024. So most employers are probably already in a good position to meet this duty. But it's certainly important to continue to review your policies and your procedures, your complaints review procedures, to make sure that all anti-harassment measures are regularly reviewed and updated. Now, I'm now going to come on to have a look at some of the other changes which are envisaged under the bill, and when we might see such changes come into effect. Now, another big headline was the effect of the bill on 0 hours contracts, and there was a lot of talk that the bill would ban the use of 0 hours contracts entirely. Now, the bill doesn't ban 0 hours contracts, but what the new laws aim to ensure is that 0 hours or casual workers who in practice work fairly regular hours are given a contract which reflects that regular working pattern. In addition, such workers will have increased reliability and certainty around their working arrangements through an enhanced right to be given notice of shifts and notice of cancellation of shifts with a corresponding entitlement to compensation. So 0 hours or casual regular hours workers, so could include roles such as exam invigilators, will have a right to be offered a contract reflecting regular hours, and will have a corresponding right, if applicable, to be given notice of shifts and compensation for shift cancellations. Now, there have been calls for the duty to offer guaranteed hours to be replaced with a right to request or a right to claim guaranteed hours, simply to reduce the administrative burden on employers. However, despite the House of Lords putting pressure on the government to amend the bill and to take this into account, so far such amendments have been resisted. Again, this is something that is being debated in the House of Lords again today, so we will need to watch this space to see whether any such changes are ultimately accepted. But assuming that the government proceeds as intended, the new right to a contract will apply to workers, again, on 0 hours or on a minimum number of guaranteed hours contracts. And if their hours regularly exceed the 0 or minimum hours over a reference period, which is expected to be 12 weeks, they will have to be offered a new contract reflecting those regular hours. Now, there will be some exceptions to that requirement to offer guaranteed hours. So if a worker resigns, if they're fairly dismissed, or quite crucially, if there is a collective agreement in place which disapplies the provisions. And the use of 0 hours contracts may still be permitted where a fixed term arrangement is deemed to be reasonable, although we don't yet have a definition of what is meant by reasonable in these circumstances. The thresholds for minimum hours, notice periods, and the amount of a cancellation payment are all subject to further consultation. But the changes are expected to come into force in 2027 once that consultation has occurred. As a starting point, it's a good idea to have a look at your current arrangements, carry out an audit and identify those roles where this right might be triggered, and look at whether it is possible or it might be possible to start preparing for a more predictable working pattern request. An important reform that we are anticipating in April next year is in relation to statutory sick pay. So currently, statutory sick pay is payable from day 4 of absence, and an employee must be working or receiving over the lower earnings limit, which is currently £125 per week in order to be eligible for SSP. From April next year, it will become a day one entitlement, and it will the lower earning limit will be removed. Therefore, SSP will be payable to all eligible employees, which essentially means that more employees will qualify for statutory sick pay, which will have a knock-on effect and an increase in wage bills for employers. So definitely worth having a look at your sickness policies, making sure your arrangements and your policies will reflect this once it's introduced. We will also see some changes to collective redundancy consultation. In April 2026, we're likely to see the increase in the protective award. So where an employer is found not to have properly followed the collective redundancy process, they can be awarded a punitive payment of 90 days pay per employee. This is doubling to 180 days. So the risks of not properly following a collective consultation process will become much more costly. And in 2027, we are likely to see some changes to the current thresholds for triggering collective redundancy consultations. So currently, an employer needs to collectively consult and notify the Secretary of State when it is proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less. Now, the reference to one establishment is proposed to be removed, so the thresholds will apply across the whole of an organisation, which could affect, for example, multi-academy trusts with more than one site. And there will also be a new threshold as yet to be determined. We are seeing some increased dismissal protections following during pregnancy and following a return from maternity leave. Currently, enhanced protections apply for within a protected period for redundancy dismissals, but what the bill proposes to do is cover other dismissals aside from redundancy, which take place during pregnancy, maternity leave, or within 6 months of return to work after that leave. And it will also apply to other forms of family leave, such as adoption leave, shared parental leave, neonatal care leave, and bereaved partners paternity leave as well. Again, we're expecting that one to come into force in 2027. There will be a day one right to bereavement leave of at least a week for qualifying employees, and the regulations will set out the necessary relationship with the person who has passed away in order to qualify for the leave. It's possible it might follow the same definition used in time off for dependents. And in April next year, paternity leave and unpaid parental leave will become a day one right, removing any length of service requirements for such leaves. So again, that's an important one to be aware of, as policies will need to be updated to take into effect these changes. We're also going to see in October, expected next year, restrictions on the use of fire and rehire, also known as dismissal and re-engagement. And it will be automatically unfair to dismiss an employee who refuses to agree changes to their contract which relate to their pay, pension, their hours, holiday entitlement, or other matters specified in regulations. It will also make it automatically unfair to replace or re-engage them for refusing to agree to those changes. The result of this is that employers will have less flexibility to make changes than is currently the position. There will be some very limited exceptions as to when such changes will be permitted. So it's worth certainly having a look now at your contracts and considering whether or not they do give you enough flexibility to make any changes that might be required. We're also seeing the introduction of menopause and gender pay gap action plans. So regulations will come in on a compulsory basis in 2027 to require employers who have more than 250 employees to produce and publish both menopause action plans and gender pay action plans with specific penalties for not doing so, and certainly worth having a look at particularly your menopause policies and considering introducing one if you don't already have one. Finally, we are also going to see the introduction of the Fair Work Agency, which is going to be a new enforcement agency, new enforcement body who will oversee the enforcement of claims for things like holiday pay, national minimum wage, statutory sick pay. So currently those rights are typically enforced through the employment tribunals, but this new body will have power and remit, which again, we're waiting for further details, to enforce such claims. Now, particularly the enforcement of holiday claims, we can think is likely to be significant. In education, particularly with irregular hours or term time contracts, holiday pay can lead to disputes over entitlements, and the introduction of this agency is likely to mean that it will become easier for employees to enforce their rights. So again, it's worth keeping an eye out for further announcements in respect of when this is likely to come into force. I appreciate we've reached the end of the session. I hope you found today a useful overview of the bill in terms of what's helpful to have on the radar and where you might need to start thinking about making some changes. Please do follow us on LinkedIn for further announcements as we become aware of them in relation to the progress of the bill. And if you haven't already signed up for our newsletter, you can do so, which again will provide timely updates as and when things progress. That leaves me just to thank you for coming, and hope you have a great rest of the afternoon. Thank you.